Yes. Item 23. 23. Okay, both sides represented. 2 weeks on the prayer made by counsel of the petitioner. Yes. 20. Okay. 22. 22. 24. And 41. Okay. Same order. Okay, just check nature of interim order and then extend. Give it, we don't know. We are not giving a fixed date. Let the courtmaster take a call. 30. 39. Okay. We'll try to see. We can't give time. We'll try to be in the court. 20 and 29. Okay. 20 and 29. Same order. 2 weeks. Listing give to the courtmaster.
Daily list item 1 for motion.
তাতে গৈ পেলাই কথা পাতি লওক চিফে কমিশন দিছে নহয় ন চিফে নিদিব পাৰে তাৰমানে হয়তো চিফে নোটিচ নিদিব পাৰে ন ঠিক নাই কিন্তু সুধি ল'ব আমি বোৰ্ডত নোটিচ দিম নেকি আমাৰ কোৰ্টত ছেকেণ্ড হাফটো মই তেনেকৈ যাম সুধি ল'ব ক্লিয়াৰ কৰি ল'ব Yes, Mr. Ahmed.
LCR is received Millard. And the petitioner is not in interim Millard, though the case is immediately filed after passing the impugned order Millard. And in this case, Millard, petitioner examined his father, her father Millard.
Which is the best document you have?
Best documents is equal certificate Millard. School certificate is spent is 28.
Ms. Verma will give him bail. He has reasonable
it for hearing because written statement has nothing in it.
I could,
Now,
No, whatever be, but he had otherwise come within time, but it was matter was heard and kept reserved. So
entitled to.
at least the projection.
Lordship is having a pattern of set SOP lordship follows.
There must be, you must be following some pattern. Otherwise,
This I've seen that.
yes, yes.
otherwise this ultimately, whether we like it or not, the lawyers appearing for the petitioner have to survive.
Lordship's experience from here to there.
So therefore, tomorrow may not be a good day for them, but today at least.
Yeah.
Lordship interim and fixed for hearing.
Fixed for hearing, okay. Heard Mr. A.M. Ahmed and counsel for the petitioner. All the respondents are there. Opinion is at page
এনেকে হ'ব লাগে
47,
কেতিয়াবা যে
28/12/2023, passed by so and so and so and so. Thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Because otherwise we don't find a good case. The certificate could not be proved in accordance with the established principles and a lot of age gap. But still today we don't have time to hear it. Notice extra copies within 2 days. As the records are already received, the court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. Next, the prayer for bail is opposed by the Learned Standing Counsel for the FT matters on the ground that even if the documents exhibited by the petitioner is taken it's in its face value, the petitioner has failed to demonstrate that he is a citizen of India. Next, be that as it may, in view of the projection made in the writ petition, bail of rupees 10 days time to take bail of rupees 5,000 to the satisfaction of SP Border, Golaghat. Next para, as the records are received, list the matter for hearing in the week commencing 18/8/2025.
Item 2.
May I please, Your Lordship, my lord?
Yes.
My lord, in this case, my lord, I was allowed to file my additional affidavit, my lord, bringing on record the linkage of the petitioner along with his mother, my lord, and sister, and along with his father also, my lord. My lord will kindly have a look at the running page of, my lord, additional affidavit at page 98, my lord, 96, my lord, the vernacular, my lord. I'm sorry I could not produce the certified copy. I had very short time, my lord. In the bottom, my lord, serial number 358, my lord, Jaleka Khatun. She is my mother and she is the wife of Abdul Mannaf, my lord. Left side, my lord, along with the photograph. My lord.
300.
358, my lord. The
Three-
last one in the left side of the bottom, my lord.
358 years.
She is Jaleka Khatun. She is the wife of Abdul Mannaf. She is my mother, my lord. And my name is reflected just above that, my lord. 356, my lord. Abu Tahir. Abdul Mannaf. I am the son of Abdul Mannaf. Same person, my lord. And just below my name, my sister is there, only sister, Firuza Khatun, my lord. Along with my father's name, Abdul Mannaf. She is the daughter of Abdul Mannaf. Same house number, only the house number of me is, my lord, a little bit different, my lord. 215, since I live in a separate entity, my lord. And their house number is 216, my lord. Just the next house. And that may kindly be confirmed, my lord, along with the other voter list at page 98, the vernacular, my lord, as well as the land document also, my lord. Page 98, my lord. My mother's name has been reflected in the second, my lord, second column of top, my lord, second. Right hand side, second, Jaleka Khatun. Husband is Abdul Mannaf, he is my father, along with the photograph. And the name of Firoza Khatun is the extreme right, my lord, top. Firoza Khatun, she is the daughter of Abdul Mannaf, my lord. And now, if your lordship kindly come to the land document, the Jamabandi copy, my lord. The name of all the persons, my lord, have been reflected together, my lord, in the Jamabandi copy.
Which entry?
My lord, page number 99 starts from this land document. my lord.
Yes,
Yes, my
Your-
name, and if your lordship kindly turn to the next page, page 100, my lord,
yes.
the vernacular, my lord. My elder brother's name, Muhammad Surhab Ali, appears at serial number 2, my lord. And another brother, Qasim Ali's name at serial number 3, and my name appears at serial number 4, my lord, Abu Tahir. If your lordship kindly go to the, my lord, remarks column at page number 103, my lord. The name of all the persons have been reflected together, stating that they have inherited land from their father Abdul Mannaf, my lord. Third paragraph in the page number 103, my lord. 103, my lord. Third paragraph from the top, my lord. চক্ৰ বিষয়াৰ 31/8/2016 তাৰিখৰ নামজাৰি গোচৰৰ ছয়েনশ হুকুম মৰ্মে 125 নং দাগৰ মাটি আব্দুল মন্নাফৰ স্থলত উত্তৰাধিকাৰী সূত্ৰে সুৰহাব আলী পিতৃ আব্দুল মন্নাফ, মোহাম্মদ কাছেম আলী পিতৃ আব্দুল মন্নাফ আৰু মোহাম্মদ আবু তাহেৰ, দিছ ইজ মি মাই লৰ্ড, পিতৃ আব্দুল মন্নাফৰ নামত নামজাৰি কৰা হ'ল। Sohrab Ali's name also appeared, my lord, was reflected in the voter list, my lord, the page.
This land document, this date is 24, right? 2024.
The 2024 to is apna certificate copy list.
That is yes.
That to dia আছে, এটি আছে 2016 আছে, 16 of book. Just wanted to show the linkage. Linkage is there. My lord, during deposition, my lord, the petitioner had spoken to us, my lord, he had stated his mother's name as Jaleka Khatun and also the younger sister's name as Firoza Khatun, my lord. That is there on record, my lord. The main petition, my lord, at page 70, my lord, annexure 30. The deposition of the petitioner is there, my lord. No. The one I having a certain. The next of the film, certificate copies of Bishop Lisa, of Bishop Series. 24 liters. This man could obtain the certified copy on 3/2/2024, my lord, and the same year, my lord, he had preferred, my lord. He is very poor person, my lord. He could not bear the litigation expense, my lord. In the court fee, my lord, the date has been reflected as it was taken on, obtained on, my lord, 3/2/2024. I'm praying for.
That is for you to introspect why you are charging higher so that people can't pay.
No,
It
my
is
lord.
for you to
Sometimes, my lord,
introspect.
there are so many people.
Okay,
my lord.
but
cannot be
you've been able to show a connectivity, but still there is a gap because those documents were not exhibited earlier.
Yes, my lord. I'm
We
praying for interim protection only, my lord, at this stage. my
we
lord.
give you protection not to be deported.
Or she will kindly, my lord.
2019 opinion is being challenged now, 24.
Yes, my lord, but I am praying before your lordship, my lord, just, my lord, to have the bail, my lord. This is my humble prayer before your lordship.
Lordship,
At least in this case, my lord.
reported is enough.
But since my lord, since
You get a
I
protection not
got a, my
because
lord, permission from this honorable court to file my additional affidavit, my lord. Therefore, I am praying before your lordship, my lord, just to consider my prayer only in this case, my lord. Otherwise, I could not have prayed, my lord. Since he
No,
had,
since there's a lot of delay, we are
since
giving
he
you
had
that
obtained the
protection, but
certified copy just my lord in the previous year, and immediately thereafter he had preferred the my lord writ petition, my lord. He's a very poor person, my lord. Now she will kindly bear with me, my lord. She will kindly protect me, my lord.
no, in 2019, we can't give you protection right now, but we'll examine your matter.
Frame for bail.
You'll be
lordship will
protected
be-
from deportation.
He may not be arrested, my lord, at least.
No, that we are not granting right now.
Because, my lord, on the other hand, my lord, he is the grand, my lord, son of the Deputy Speaker of Assam, my lord. That I also, my lord, I have brought into record, my lord.
Oh, actually, this is that matter.
That matter, my lord.
Okay.
This is a difficulty. my lord.
Difficulty or privilege?
No, this is a difficulty. He could not prove it. But it's a fact that he's the grandson of.
Okay, we give you that protection then.
My lord.
But then I did not catch it that you were referring to your mother. That's why we gave you an opportunity to bring it.
Yes, my lord.
Okay. Had Mr. Zaid Ahmad and counsel for the petitioner also had all the respondents are there. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated, it's page 76, 21/8/2019, passed by so-and-so in so-and-so IMDT, reference IMDT case number so-and-so, dated so-and-so, by virtue of which the learned tribunal has held the petitioner to be a foreigner post 25 to 1971 stream. The learned counsel for the petitioner submitted that in the meanwhile, the petitioner has filed an additional affidavit to bring some more documents on record to link his lineage with his projected mother. Next paragraph. Keeping in view the inordinate delay in assailing the opinion, impugned opinion, comma, keeping the issue of maintainability open, the court is inclined to issue notice returnable. Make it a rule returnable on 18/8/2025. Requisite extra copies of the writ petition be served on CGC State and Departmental Council within 2 days. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that the documents which are exhibited by the petitioner does not inspire confidence, and therefore as the petitioner could not establish his link with his projected parents, comma, the petitioner is not entitled to any interim bail at this stage. When there is inordinate delay in challenging the impugned opinion. Next paragraph, either as it may, in view of the projection made in this writ petition, the court is inclined to grant bail to the petitioner, namely so and so, 10 days time to take bail of this 5,000 to the satisfaction of also
SP border Morigaon.
SP border
Morigaon.
Morigaon. Next one, as the records are already received, this is the matter for hearing in the week commencing on 18/8/2025.
My lord. Deeply applied.
Item 3.
কিবা খবৰ আছে? গভর্নমেন্ট কোড আচ্ছা গভর্নমেন্টে খবর লব আচ্ছা মই কওঁ আমার মানুষ অলরেডি কিন্তু ঘুরাই দিছে অলরেডি ঘুরাই দিছে
Mr. Pine, I was 1 or 2 days back reading somewhere, there's a notification of 2006 or 2009 in Foreigners Matters regarding the manner of their deportation and holding. Can you give us a copy if you can find one? We have no urgency in the matter. By Monday, you can just search for it.
I can provide 2009, there is a, between 2009, 2011, and latest, now there is a notification in second also.
Please give us all this connected regarding this holding center.
Yes. Holding center, now it is, as your lordship, I have mentioned last day. They can use this, yes, it is holding center, no, earlier it was detention center.
Little center.
Whatever is there, I forgot. I was reading somewhere
Newly created, no?
I was reading somewhere and then I found reference to this, but I could not lay my hands on that notification.
There is a notification in 2009, there is an 11 and 11, now it is another.
Please give me a set on this. Yes, Mr. Ahmed,
Milord, in
you
this
have got
case,
the
Milord,
Wakalatama? You have got the Wakalatama? You met the,
yes, Milord.
so. you
Milord,
can-
what happened in this case, Milord? After detention, Milord, after few days, Milord, 1 month, Milord, Shafiqul Islam, Milord, at present residing his house, Milord, Home Department return back, Milord.
Pardon me?
Shafiqul Islam, here is a petitioner is the Nazifa, and her son Shafiqul Islam, who is detained by the police, Milord. Actually, what happened in this case, Milord, one Shariful Islam, Milord, page 29, Shariful Ali, one ex party order passed, Milord, and instead of Shariful Ali picked up Shafiqul Islam. Illegally, they had alternative prayer to it.
Yes, page 29.
Yes, Milord.
Yes.
One Shariful Ali, son of late Kudus Ali, care of Salikapur to ward number 3, Milord. Whereas, Milord, the petitioner residence is falls under Shantipur, village Shantipur, ward number 3, PS Golaghat, Milord. His son is detained, Milord, 1/6/2025. Son's name is Shafiqul Islam, Milord. And Milord, to my information, Milord, after kept in the Kokrajhar Holding Center, Miller. Thereafter, the state government, Home Department.
You see, this, come to page 31.
Yes.
Whose opinion is this?
Yes, this opinion in favor of the mother of the petitioner, Miller.
Mother of the petitioner.
No, Miller.
Now you see the husband of the name of the husband of
Yes,
the
Abdul
petitioner,
Quddus.
Abdul Kuddu.
Koko. Actually,
therefore-
Quddus.
And in this affidavit, you say it is Nafiza Khatun.
Yes,
You see, she writes Abdul Quddus
yes.
in the affidavit, page 12.
Right.
So
Yes.
therefore, by convenience, you change your name.
No, Miller. Actually, Miller, what happened in this? The that Shariful Ali is available, Miller. To my information, Miller. That Shariful Ali is available. And that's why, Miller, Home Department handed over the petitioner's son to the family member subsequently, Miller.
He has been handed over.
Yes, Miller. Wrongly detained, Miller. So, what is successful idea? Your detained police. Yeah.
Mr. Payang,
My lord.
if he is wrongly detained, we'll give a order that will not be picked up again without order of the court. Because can't be harassed if he's not the proceeding.
That's why, my lord, what probably there is a mistaken identity. What my understanding is, because, my lord, I like to solve.
It will give.
Etu kesore?
আমাদের এই তো অপশন send guideline madam is in direction of the guidelines. Whereby madam the revocation process was directed to be initiated in a proactive manner.
Formal revocation process start from 2031.
Here, madam, as per this direction.
It's okay, will you give us this entire set?
Yes.
If you give it on Monday, we have no urgency in the matter.
Yeah.
Mr. Ahmed and Mr. Pang, then we protect him. He will not be arrested again without.
Father name is same madam. The ward number is also same. That's why he was, the name is also on both civil.
You also had the same impression. Okay. We close this matter then. We give you protection not to be arrested without order of the court. In connection with in connection with restricted to the opinion at page 29. Page 29 as well.
Page 6.
Heard Mr. A.M. Ahmed and counsel for the petitioner. All the respondents are there. Next para. by filing this writ of habeas corpus, the petitioner, namely Najida Khatun and Najifa Khatun, has prayed for production and release of her son, namely Sofikul Islam, who was illegally detained by the police personnel from border division of Golaghat police station. On which date you have apprehended?
1/1/6/2025.
On 1/6/2025. And since his detention, his whereabouts was unknown. Next para. The learned counsel for the petitioner projects that though the petitioner has a name similar to the proceedee in case number FTG, full stop, that is at page 29. Proceedee so wherein by opinion dated 16/12/2024, the said proceedee was declared to be a foreigner, but he is not the said proceedee. Full stop. Accordingly, by order dated 26/6/2025, this court had directed the learned standing counsel for the FT matters to obtain information about the son of the petitioner. Full stop. Accordingly, on 27/6/2025, the learned standing counsel for the FT matters had submitted that as per instructions received by her, the son of the petitioner was currently being held at the holding area, 7th Assam Police Battalion, Saraikula, Kokrajhar. And accordingly, this court had directed the in charge of the said holding area to allow the petitioner and one family member to meet the detained person and to obtain his signature in the Wakalatnama by producing a certified copy of this order. Next para. Upon instructions, the learned counsel for the petitioner submitted that in the meanwhile, the border police authorities and the in charge of the holding area, having been satisfied with the separate identity of the petitioner with the identity of the petitioner, separate, so not separate, different from the proceeding in case number FTG 998 of 2011, have released the detained person on when?
1/1/6/2025.
No, he was released when?
I will provide this date, Milord.
Okay, no, he is released in the meanwhile. Next para. Accordingly, it appears that the petitioner was apprehended on mistaken identity, treating the petitioner to be a the proceeding in FTG 998 of 2011, referred above. Next paragraph. Accordingly, the Superintendent of Police within bracket border bracket close Golaghat comma having released the son of the petitioner, namely Sofiqul Islam, on being satisfied with this, on his purported satisfaction with the identity of the petitioner to be different from the proceeding in FTG 998 of 2011, comma, the said authority shall not take the son of the petitioner, namely so and so, again in custody in connection with opinion dated 16/12/2024 passed in FTG 998 of 2011 without an order of the court. Next paragraph, the petitioner shall produce a certified, the son of the petitioner shall produce a certified copy of the order. Shall produce a certified copy of this order before the Superintendent of Police, Border Golaghat, to bring the order to the notice of the said authority. Next, accordingly, on satisfaction, comma, this writ petition, this habeas corpus petition stands closed.
Item 4.
4 is also, my lord, home department handed over the petitioner's brother and sister-in-law. Same day,
Same day means
Same day, my lord. I will provide that
Okay.
which date, my lord, the respondent authority handed over the elder brother and sister-in-law, Ismail Ali and Ambiya.
you have instructions.
ঘুরাই দিছে ঘৰত আছে কাৰণ এই কেছবিলাক বেলেগৰ নামত আছে মিলা নাই
Because the case projected, there was no opinion, but it was taken in custody. You have intimation, no?
I, problem is that my learned friend has not sought copy to us.
subsequently sub
No, because you did not ask them to serve extra copies.
itu তো চপে কপি দেওয়া হয়েছে তো সেলাই মিলাই কাজ আছে
Password has to return my lord, as per my learned friend 65.
Here also we give that protection. If they are not the proceeding, they will not be taken into custody.
Yes.
No, here we'll need you need
Yes,
instruction because on the last date, Ms. Verma was there. She informed us that against the petitioner, there was an opinion of 24/8/2023, and against the sister, there was an opinion dated 26/11/2018.
12 যেটা matter আছে। হুম? একটু ফোন করে বলে দেবো। ফোন করে দেওয়া কোন জায়গায় কি করিস? ঠিক।
But Mr. A.M. Ahmed, and also the petitioner, all the respondents are there. Next, madam. By filing this habeas corpus petition, the petitioner had prayed for production and release of the of his younger brother and brother-in-law, namely Ismail Ali,
Elder brother,
not brother.
elder brother and sister-in-law.
Look at paragraph 2. You say brother and brother-in-law. She appears to be a female name, but you say that she is a brother-in-law.
Wife of Ismail Ali.
So she's your elder brother.
Yes, madam.
Okay, his elder brother, namely Ismail Ali, and elder brother's wife, Ambia Khatun, AMBIA, Ambia Khatun,
At 28/6.
who were taken into custody on 24/5/2025. Without informing the whereabouts of their whereabouts to the petitioner. Next paragraph, pursuant to order dated 26/6/2025, the learned standing counsel for the FT matters had submitted that the said detained persons were were then being held at the holding area, 7th Assam Police Battalion, Saraikula, Kokrajhar, and according to the instructions, as against Ismail Ali, there was an opinion dated 24/8/2023 passed in case number FTG 520/2011 and against Ambia Khatun, there was an opinion dated 26/11/2018 passed in case number FTG 648/2011. In both cases, the detained persons were declared to be a foreigner declared to be a foreigner. Next paragraph. Upon instructions, the learned counsel for the petitioner submitted that during the pendency of this habeas corpus petition, on
28/6 madam.
huh?
28/6/2025.
Released on 28/6/2025.
Released and handed over.
And handed over to their family. Moreover, it is submitted that as per instructions received by him, the concerned border police have found out that the said detained persons were not the proceedings against proceedings in FTG 520 of 2011 and FTG 648 of 2011. Next para. In view of above, and as the detained persons have since been released from detention, courts of the considered opinion that
Like that to 2028.
this habeas corpus petition has served its purpose, and accordingly the court is inclined to provide that the Superintendent of Police border Golaghat. This is Golaghat.
Yes.
Yes.
That ensure that before taking the detained persons named above in custody, they would custody in connection with opinion, if any passed by the foreigners tribunal, the said authority shall first ascertain the identity of the detained persons, namely Ismail Ali and Ambia Khatun, before taking any action. Next para. The petitioner is the said detained persons are permitted to produce a certified copy of the order before the Superintendent of Police, border Golaghat, to bring the order to the notice of the said authority. Next para. Accordingly, on satisfaction, this petition stands closed. Habeas corpus petition stands closed.
Item 5.
Here's this case where the petitioner's identity method. So
Yes.
was not informed to have been handed over to BSF. Then the BSF authorities will say that the person who is there in their custody has a different husband's name
Yes,
is different.
yes,
That verification was asked to be made.
yes. You got the information.
Yeah, Robert, did you? We have the
Little.
notification.
মানে কি identity control লাগিছে যে
Itu নহয়.
husband নামটো কৈ দিবি
কৈ দিলে এটা কৈ দিম ন
And so when we had made the chili, this misplaced something. Three copies. What happened in your case? You got 8% last year or the instruction at least one of the whole.
ইয়াত কৈছে ভোজন বিধি হাইপাৰ অব্জেক্ট হিচাপ Then it is a happen of vision people. In which is
Serial number
not
8.
vision people, not.
This is the original one document.
Just a moment, we will read this, then we'll understand. Exactly. Gives me prospect. But then we'll have to ask Mr. Datta,
My lord,
as per the instructions received,
my lord.
we will make it a part of order. It depends on how you make your response.
My lord.
The documents received disclose that the petitioner Abdul Razak has an alias of Abdul Manaf. That's number one.
Right.
Number two, the instruction received from the state and handing over to the BSF is Dojan Bibi, wife of Abdul Razak. But the Superintendent of Police categorically says that you have a alias of Abdul Manaf.
They have specifically asked him, my lord. He said, no, I don't write any other name, my lord. And when he filed the, my lord, when his wife filed the.
Show this to him, last page.
I understand that they may have that information, but then.
No,
Uh,
you
what I
have to be
spe-
satisfied because it leads to a.
Because when Mala, she filed the case, Mala, page 29 before the Honorable Court, Mala, this Honorable Court, Mala. There also she named her husband as Abdul Razak, Mala. And daughter of Mainal Haq.
But this is, you see, this letter is predated, that means 18/6. Here, with reference, I will inform you that Dojan Bibi, wife of Abdul Razak, so and so. So this is the first instructions which have come.
Yes, Mala.
And then next page, before that, you come to the first page of this documents.
Mala.
Second page is 2 and 3.
2 and 3, Mala. Yes.
Para 2 is, however, on 25 to 25, on Dojan Bibi, wife of Abdul Razak, daughter of Moinal Haq, was declared to be a foreigner. She was sent to the holding center. Para 3,
Declared as a foreigner.
also same.
Since this is-
Dojan Bibi, wife of Abdul Razak, daughter of Moinal Haq.
Yes.
And then she was handed over to the border police.
Mala.
And this BSF sector headquarter, Panbari.
Mala.
And after that, there's one page, second page you come, Second number is the serial number 8, Dhubri, Dojan Bibi, wife of Abdul Razak.
My lord.
So this is the person handed over.
The daughter, father's name is same, it's telling, my lord.
Yes.
Father's name is telling, my lord. And the case number, my lord, case number also is telling, my lord. That way is telling, my lord. If, my lord, they have handed over, my lord, her to the BSF, my lord. And, my lord, BSF, thereafter, the submission was made that the person has been deported, my lord. Then they, my lordship, may kindly turn to my page 17 and my affidavit. My lord. They must, my lord, produce this certificate, my lord, handing over and taking over note, my lord. This is the procedure they've been following, my lord. Page 79 of my additional affidavit. This has been done with regard to others, my lord. They must show, my lord, to whom it has been, she has been handed over, my lord. Page 79, my lord, additional affidavit I filed, my lord. This is a similarly, my lord, document with regard to, my lord, how, my lord, this handing over and taking over takes place, my lord. My lord, the Bangladeshi officials, my lord, received them, my lord, then.
You obtain instructions, Mr. Adhikari, in what manner? He's referring to page 79. You have a copy of that affidavit? You've given him a copy?
Yes, my to serve, my lord, if I'm, my lord, I had instructed to serve it to everyone, my lord. This fine long time back, my lord.
Okay. You get instructions in the meanwhile, in a manner which is handed over. Heard Mr. M. Dattar and counsel for the petitioner. All the respondents are there. Next person. Pursuant to order dated 18/7/2025, comma, the learned standing counsel for the FT and border matters has produced a copy of a bunch of documents received in instructions from the Assam Border Police Organization, by which it is projected that the declared foreign national, namely Dojan Bibi, DOYJAN, Dojan Bibi, is the wife of Abdul Razak, ABDUL RAZZA. He writes EJJAK, REJJAK, within bracket, in instructions mentioned as Abdul Razak, RAZZAK, alias Abdul Manaf, MUNAFF, was received by the superintendent, transit camp, Matia Gwalpara. And that on 26/5/2025, Dojan Bibi, within bracket, written as DOIJN, Dojan BIWI, wife of Abdul Razak, RAZZAK, alias Abdul Munaf, MUNNAF, bracket close, was handed over to the Border Security Force, sector headquarters, Panbari, next para, it may be mentioned that on 18/7/2025, by order dated 2025, it has been recorded that the Lanet CGC had produced instructions from the frontier headquarters, BSF, stating that the The Doijan Bibi, Doyjan Bibi, wife of Abdul Munaf, MUNNAF, was handed over to the BSF and she was sent back to Bangladesh from the area of responsibility within bracket AOR, bracket closed, of ad hoc 2503 Battalion, BSF, Dhubri on 27/5/2025. Next paragraph. The Learned Counsel for the petitioner has referred to the documents and appended to Annexure 11 appended to the additional affidavit filed on 10/6/2025 and submits that if the wife of the petitioner has been handed over to the Bangladesh authorities, there must have been some documentation next paragraph. The learned CEC shall send a downloaded copy of the order to the concerned authorities to obtain instructions regarding handing over and taking over. Note, if any of Doijan Bibi, wife of Abdul Razak.
Doctor, don't follow the instruction. Because there is no handling, please say let's move back.
No, just get information. We have received it, but push back whether there is an instruction or not. Let it come. It is not there.
Unless it's something very serious, man.
No, for that you have to deal with it.
No, but
Human beings not use the
human
declared foreign national sent
Malad,
back.
human beings cannot disappear like that, Malad. Human beings cannot be made to disappear like that, Malad. This is the amount of human trafficking, Malad. It's a very serious issue, Malad.
I don't know. We'll have to make
Foreigners fine, Malad. Foreigners fine, Malad. But then there is a procedure established by law, Malad. That has to be
that we'll
followed,
have to
Malad.
agitate.
As person has disappeared, Malad, cannot disappear to thin air, Malad. They can say that
Once
push
is
back.
not a foreigner, one is not an Indian national.
Well, that is Malad, that has a procedure to be followed, Malad. Human being cannot disappear like that, Malad. If they're saying that they have not, there is nothing to show, Malad, that this has been handed over, Malad. This is a very serious issue. Malad, a person, and pushback is something different, Malad. Pushback and Malad, the deportation are two different issues, Malad. Pushback is someone who's been caught in the borders. Here, they were in the custody of the BSF. This is the procedure followed.
We
Malad.
don't know, but you have to make that challenge.
Well, I understand that, Malad, but then, therefore, saying that, Malad,
No,
I have
it's
already
okay.
challenged that, Malad, saying that this is, Malad, our whereabouts are not known. This is my specific case
So
here.
once it is pushed back, there's nothing remains in the writ petition.
No, Malad, pushback, they have to show, Malad, that, well, otherwise this person couldn't have disappeared, Malad. Pushback, I understand, Malad. Pushback, there has to be some, Malad, papers, Malad. Because pushing back is of someone who has come, Malad, was caught in the borders, Malad. This is a person who was detained, Malad. And Malad, Lordship will see, Malad, the notification which they have produced, Malad, recently, Malad. Malad, which was produced, Malad, in other item, Malad, item number 8 will be relied upon, Malad. There, the Malad, instructions are very clear, Malad. There has to be a proper record of everything, Malad. They're, Malad, not following their own guidelines, then, Malad. The guide, Malad, in item number 8, Malad, where the issue was, Malad, whether they've been detained, Malad. My learned friend on the other day relied upon a notification which your Lordship directed me to a copy to be served on me, Malad. There are specific, Malad, guidelines issued, Malad.
No, that's okay, but you see, you have to file a fresh petition to make that challenge.
My
In
case,
this,
my case here, Malad.
in this, the habeas corpus petition shows that it has been pushed back. If it is illegal, you'll have to make that challenge.
Malad, that is my specific case here, Malad, that the person has disappeared. Pushback is some, Malad, they are saying that we don't, Malad, we have just thrown her somewhere. That cannot be the case, Malad.
But it is, they are giving it, you'll have to make a challenge to that. The procedure adopted is illegal is not the subsequent of challenge.
True, Malad, but then here are the cases of disappearance of the person. They said that we have pushback. Then they don't have anything to show that there's been pushback.
They're giving a statement. It's a state giving a statement.
It's true, Malad. State giving a statement, but then without, Malad, following the, Malad, procedure, Malad. They have their own established procedure. And this is not my procedure,
That,
Malad.
you see, For that, what can we do? We do in this writ petition?
Well, since the person is not there, the case is that the person was picked up, she is missing. Now, that is the case before Lordship, my lord.
And that's an acceptable proposition.
No, acceptable proposition, my lord, they have their own policy, my lord. This is not my policy, my lord. This is their policy. Now, they are saying that we have not followed our policy and the person has disappeared.
So for that, you'll have to make a challenge. Can we extend the, what you call, without a prayer, can we extend that?
But then that's what my submission is. This itself is a petition that the person is missing, my lord. Otherwise, my lord, this is the same thing I'll be saying, my lord, again, my lord.
You have
Only-
to say that
only with
again.
the-
You have to
only
make a
with the-
challenge or you amend it, whatever you do, but this, with this prayer,
My lord.
you'll have to close it.
My lord, closer will be meaning the same. I'll be filing the same petition, my lord. Now
So
that pushback.
That's for you to decide.
That pushback, my lord, I will not, the ultimate.
That's for you to decide what to
end of the
do.
matter, my lord, is that the end result today, my lord, is that the person is missing. There is,
It's
they
been
cannot
missing.
say.
Once
cannot
they say it's pushed back,
Yes, my lord. Once they say it's pushback, my lord, then they must have, my lord, handed over to some official, Bangladeshi official, my lord, let them produce
if
that.
that procedure is not followed,
My lord.
can we convert this habeas corpus petition into that, with that sort of prayer?
My lord, my submission would be yes, my lord.
No.
Uh-huh.
You don't
Lordship,
think
will
so?
grant me some time, my lord, then think over, my lord. I'll just, my lord, if necessary, I'll file a fresh application or may amend it, my lord.
Whatever you do, so that last line you change it, you'll have to say that the CGC has submitted that the said detained person, namely declared foreign national, namely Dojan Bibi, wife of Abdul Munaf, MUNNAF, has been pushed back to has been handed over to the sent back from Bangladesh from the area of responsibility of ad hoc 2503 battalion, only that much. First off, on a query of the court, the CGC has submitted that he has not been. That as per his instructions, the said detained, the declared foreign national was pushed back to the state of, to Bangladesh. Next para, accordingly, the London Council for the petitioner prays for some time to obtain instructions and to take appropriate steps. List after,
After a week,
we make it 2 weeks. There's some disturbance in the next week.
as a
2 weeks. The instructions produced by the London CGC is returned, and the instructions produced by the London Standing Council for the FT matters is written on record.
obliged.
Item 6.
My lord, matter may be passed over for finding.
Yes,
My lord, matter may be passed over for finding, as the conducting council is on the.
now have you visited the detained person
Yes, ma'am.
and have you received the Wakalatama?
Yes,
That is,
Yeah.
the prayer in this writ petition,
এটাতে MRO দিয়ে গেল।
The purpose is served. If you have to challenge the order, you'll have to challenge it in accordance with law. There's no purpose to be served in keeping this reparation pending. You obtain instructions, you come after some time. Ask the council on record, because if you have met the detained person, then this no purpose to be served in keeping this pending. Come after some time, ask, get instructions.
Item 7.
Yes.
May appeal, Lord, sir. Ex parte order, my lord. What happened in this case, my lord? One Abed Ali Farazi who has took time and identified himself as a husband, my lord, whereas a dead person neither he is the family member not known by the petitioner's husband and petitioner's family member. And as such, subsequently 2 dates were also adjourned by the council, my lord. But that council was not engaged by this petitioner, my lord. Ultimately, ex parte order, my lord. Petitioner filed petition for setting aside ex parte order before the tribunal number 4th. Yes, because my lord, her residence fall under the jurisdiction of Juria PS, and this tribunal falls under the Juria PS, my lord. That's why she has filed the petition, my lord. That petition was dismissed, and subsequently, and dismissed with a direction, my lord, with a direction, page 34, my lord, kindly see. And therefore, on a thorough consideration of the matter, we have no hesitation to think that the petitioners are trying to confuse and delay the proceeding by taking untenable grounds as because foreigners tribunal has got no power to transfer the reference, whereas my petitioners did not want to transfer Miller. And consequently, we do not find any merit in this case, which was accordingly dismissed. Petitioner is hereby directed to file a petition with her liberty before the Foreigners Tribunal number 1, Nagaon. Accordingly, my lord, petitioner filed the petition, page 35, my lord. And that petition was not entertained and returned back after 10 to 12 days, my lord. And the petitioner become dilemma where she will file the petition, my lord. There is no specific direction. That's why, my lord, there is the delay, my lord. And in my petition, my lord, kindly see paragraph 4, 5, 6, and 8, my lord, page 35. Admittedly, ex parte petitioner did not receive any notice, my lord. And one chance may be given, my lord, court is very liberal, my lord. Please let him. Here is two adjournment petition, my lord, page 21.
No, but even in 2020, when it was returned, then also from there, it's 5 years delay.
Yes.
And we are now dealing with an opinion of 2013,
Yes.
12 years down the line.
My lord, petitioner came to know, my lord, 25/4/2018, when she was appeared before the NSK Center, my lord, for verification of NRC materials, my lord. And during this proceeding, my lord, during the proceeding, my lord, petitioner was at Golaghat, my lord. I have stated in my petition, and also in the, my lord, ex parte petition, my lord, page 35. Paragraph
You see,
4.
we have got nothing. Please come to page 35.
Yes.
There's nothing to show that this petition was presented before the tribunal. This is neither supported by any affidavit. There's no notary, nothing. We
No,
just can't say that this has been presented.
my lord, there is original copies, my lord, with me, my lord. With Okalot now, my lord.
No, but it doesn't have a affidavit. We don't know when it was prepared.
And there is a verification, my lord.
Then
20 and 9 2020, my lord, verification is. And Okalatnama is also, my lord. Roma this written this without any number.
show that petition.
Earlier part mentioned in para 8 minutes, sub para. Study name.
Return to the order of government. Completed.
Which paragraph, if you stated about the return of this petition, which paragraph? You are reading which page? 9.
Mehdi Hassan, Nagav Bar, and filed an application BS 22 2022 24 vacating the expiry order dated so and so before the Foreigners Tribunal 1 Nagav as per direction dated 7/11/2019 passed by the Tribunal number 4th Juria Nagav. But the same was returned after about 10 to 12 days from the day of filing because the tribunal has no jurisdiction as the residence of the petitioner falls under the Juria police station. Being layman lady does not have any idea, any legal idea, become in a dilemma, and as such the petitioner did not approach any other tribunal but to approach before this honorable court for appropriate reading. And the petitioner annexing the deposition of Wayat Ali husband in the writ petition only to substantiate that the petitioner no point of time received any notice. Her father also deposed before the tribunal number 4.
Mr. Ahmed, we are not satisfied with this petition. This petition which you have produced at page 35. You see in page 35, the order of return that has not been annexed. Although you have made a statement, but this is not annexed.
Milord,
a
without passing
perusal-
any order, Milord.
On a perusal of, no, it's that's different, but in this petition, this, the order of the tribunal returned, directing you to file it before Foreigners Tribunal number 1.
Yes, page 39, paragraph 8, Milord, sub para, Milord.
But you have not annexed the document.
Documents, Milord. Here is, Milord,
You see in the earlier pages, like for example, photocopies of PATA are enclosed. You say that those are enclosed, but this document is not enclosed. That's number 1. Number 2, in this petition, you say that application under section 5 of the Limitation Act has been filed. That copy you have not annexed.
a record may be called for, Milord.
Hmm?
A record may be called for, Milord.
No, but you are saying that it has been returned without accepting it.
This application, Milord, this application is returned, Milord, page 35, Milord, where is page paragraph 8, Milord, sub para, Milord. Accordingly, Miss Case so was registered. Honorable member so recorded the opposite party witness.
No,
name
that you have already annexed
so-and-so.
page, you have already annexed that. We don't have to, certified copy you have annexed.
Hmm.
You're not disbelieving it,
Yes.
but in your petition to set aside, there you have not annexed. All other documents you have annexed.
Rejection order is page 31, Milord. Rejection
no.
order is page 39.
If you are unable to communicate, please come to page 35, this petition.
Yes.
In this petition, you have not annexed the opinion, which is at page,
Milord,
which is at page 31. You have not annexed that.
petitioner filed another petition, Milord. Another petition, Milord. That petitioner was
No,
numbered
no.
as
In High Court, what do? We close this writ petition and then say that we give you liberty to come again. Then what do? You annex the copy of the earlier order.
I mean, Milord, I may be allowed to some time to obtain the copy,
And then
Milord,
you see-
I may be allowed to file additional affidavit.
We don't know about that, but you come to page 40, the subparagraph to paragraph 8.
Hmm.
You filed another petition under section 5 of the Limitation Act.
Yes.
That also you have not produced before us.
I mean, I may be allowed to time, Milord. In the meantime, I may be allowed to obtain the certificate. copy
Because
from the tribunal.
you are assailing an ex parte opinion of 8/5/2013. But then tell us, why would somebody, nobody, or somebody who is nobody, will go to the tribunal and take adjournment on your behalf?
A petition of, Milord.
You protected somebody else, third party went to the tribunal and filed petition on your behalf.
Milord, there is a petition, Milord.
No,
condemnation
we
of
understand,
Milord.
but we fail to understand the point.
And
Why
there
would
is a
somebody who is nobody?
I may be allowed to 2 days, Milord. I have to file additional affidavit annexing the delay petition, Milord. 202/2020, 20, Milord. There is a delay petition also, Milord.
You have a delay petition, you have a copy of that.
Yes, Milord.
Please pass it on. Let us see that.
A delay petition under section 5 of the limitation. Origin to size, origin to size. It will original to make it. What original how? No, sir.
Same thing here also. This is the last page you wanted to see.
This is the original. This is the original, Milord. This is the original one, Milord.
No, we wanted to see the last page. Just show us the last page.
Last page, Milord, there is a verification.
Only verification.
Yes.
Section 5 of the Limitation Act, we don't know if it can be filed through verification. So you have no,
Petition is
you have no
a
proof of swearing an
petition is a
affidavit.
layman lady, Milord. She depend on the.
No,
advocate,
no.
Milord.
The layman does
She
not file
do anything, Milord.
a layman would not,
She has put
you see,
signature.
a layman would not draft a petition.
Yes. But
It
is that
will always
duty
be
of-
assistance of the lawyer. And you have no grievance against the lawyer that he did not know how to practice law.
Actually, we have to carry it, Milord, but sometimes we also fail.
No, no. You can't accept that.
Original one, she has not received any notice, but somebody.
No, sorry, we'll have to dismiss it. Even if you bring it on record, doesn't help us.
I mean that.
We take cognizance of your production of this document, but still we don't have anything to set this aside.
Otherwise, in this case, my lord, petitioner father and her elder brother is also examined, my lord. Para 5 million. I have the certificate copy also before the tribunal.
2013 opinion, you can't accept a challenge now.
The petitioner did not receive
But-
any notice, my lord. How she
Sir,
can.
AM Ahmed and counsel for the petitioner, all the respondents are there. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the petitioner, namely so and so. Page 3, Sakina Khatun has assailed the ex parte opinion dated 8/5/2013, passed by the learned member. That is at page. Where is that opinion?
Opinion is page 26.
23. Page 26. Oh, ex parte opinion dated 8/5/2013, passed by so and so in FT case number so and so. They were declaring the petitioner to be a foreigner post 25/3/19 St. Street. Next paragraph. Referring to the documents annexed to this writ petition, comma, the learned counsel for the petitioner has submitted that the petitioner is a victim of circumstances. Full stop. It is projected that the petitioner hails from a very poor family. Full stop. It is submitted that the notice of the proceedings of case number 8861 of 2012 was never served on the petitioner. Full stop. It is further submitted that from the records of the said FT case number 8861 of 2012 within packet D, comma, it is seen that one Abed ABED, Abed Ali Faraji FARAJI had filed a petition claiming to be the husband of the petitioner and sought adjournment due to illness. First of it is submitted that although adjournment petitions was filed by a learned counsel, but at no point of time, the petitioner had engaged in the counsel and to take steps for vacating the ex parte order, order to proceed ex parte against the petitioner. Full stop. The learned counsel for the petitioner submits that the petitioner has no relationship with Abed Ali Faraji, who is not known to the petitioner, and he submits that the petitioner had never engaged any counsel. Full stop. Accordingly, an ex parte opinion dated 7/11/2019, as referred above, was passed. Full stop. The next paragraph, the learned counsel for the petitioner submits that during the NRC process, the petitioner came to know from a local, what is NSK? What is page 7? What is NSK?
NRC Shah can do.
Asha, from the NRC Seva Kendra on 25/4/2018 that she is a proceedee in FT case number 8861 of 2012, and accordingly on 2/7/2018, the petitioner had filed miss case number 2 of 2018 before the learned member, Foreigners Tribunal number 4th, Juria, Nagaon, for vacating the said ex parte opinion. Full stop. In the said proceedings, the petitioner the father of the petitioner, the brother of the petitioner, and the husband of the petitioner appeared as DW1, DO2, DW4, and made a statement that that Abid Ali Faraji was not a family member first of, however, by an order dated 7/11/2019, they said miss case number 2 of 2018 was rejected. First of, however, with liberty to the petitioner to file a petition before the Foreigners Tribunal number 1, Nagaon. Full stop. It is projected that after order dated 7/11/2019 was passed, the petitioner filed an application on 20 February 2020 before the Foreigners Tribunal number 1, Nagaon. First of, however, after 10 to 12 days, the said petition was returned as the tribunal had no jurisdiction, as the residence of the petitioner falls under Juria Police Station, JURIA. First of, accordingly, it is projected that the petitioner, being a layman, was confused as to where could she go for appropriate relief. Full stop. It is submitted that the petitioner has all the documents to show that she's not a foreigner but a bona fide citizen of the country. And accordingly, by filing this writ petition in Article 226 of the Constitution of India. The ex parte opinion dated 8/5/2013, referred above has been assailed. Next para. The learned counsel for the petitioner had produced the original copy of Annexure F to the writ petition. Full stop in the said petition, there is a reference to another petition under Section 5 of the Limitation Act. Full stop. He has produced a copy of this said application. Full stop. However, on a perusal of the copy of petition produced by the learned counsel for the petitioner, it is noticed that the said petition is not supported by an affidavit. Full stop. As there is no seal and signature of the learned tribunal accepting, keeping on record the petition purportedly filed on 20 February 2020, in the absence of any affidavit, there's no way for the court to ascertain as to whether the petitioner had presented this petition before the Learned Foreigners Tribunal number 1 at Nagaon. Full stop. As per the contents of the order dated 7/11/2019, passed by the London member, Foreigners Tribunal 4th Nagaon, Juria, the said miscase was dismissed with liberty to the petitioner to file a petition before the Foreigners Tribunal number 1 Nagaon. Stop. However, a copy of the said order dated 7/11/2019, passed in miscase number 2 of 2018, is also not found to be annexed to Annexure F to the writ petition, being the projected petition purportedly filed before the Foreigners Tribunal number 1 Nagaon on 20 February 2020. Next para. Assuming that the petitioner had filed such a petition on 2/22/2020, there is no acceptable explanation by the petitioner for filing the present writ petition after 5 years on 15/7/2025, which is after a lapse of more than 5 years. Next para. Under the circumstances, having heard the learned standing counsel for the FT matters, the court is of the considered opinion that on ground of delay and laches in approaching the court to assail the ex parte opinion dated 8/5/2013, which is after 12 years thereof, and more than 5.5 years, 5/1/2 years of passing of the order dated 7/11/2019, passed in miscase number 2 of 2018, by the learned member, Foreigners Tribunal, 4th Nagaon. The court is disinclined to entertain this writ petition, and therefore this writ petition stand dismissed on the ground of delay and laches without issuance or notice on the respondents. Next, accordingly, let a copy of this order be transmitted to the learned member, Foreigners Tribunal, Nagaon, to be made a part of record of FT case number 8861 of 2012. We are returning this document. We'll take a short break and come back.
Item 8.
Maybe yes. And this matter relates to ex parte matter. And this only ex parte order on 27/3/2019. Uh, 2019 matter. Petitioner did not receive any notice. It's a common opinion.
Oh, impossible.
We'll keeping the issue of maintenance be open, but we'll call for the records.
In the meantime, some protection, police is running after the
He will not be deported only that much.
and Miller. So some
2019.
protection maybe Miller. She is a lady Miller. Yes.
See,
ये थोड़ी लोग हुए थे।
heard Mr. A.M. Ahmed, land counsel for the petitioner. All the respondents are there. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 27/3/2019, page 14. Your serial number is serial number 1.
One.
Serial number 1. Passed in common with another with connected with not connected with 9 other cases whereby the petitioner was declared to be a foreigner post 25/3/1971 stream. After holding that the notice was duly served in terms of para 3 within bracket 5 within bracket F of the Foreigners Tribunal's Order, 1964. Issue notice returnable on so and so. Give it fixed date after 4 weeks. Extra copies within 2 days. The registry shall call for the records of case number F. Serial number 1, page 14, case number so and so. From the learned member of a foreigners tribunal Jorhat. The usual process as will be raised by email through the following email address. Next, the learned concept, the prayer for bail shall be considered on receipt of the tribunal's records. Stop, however, comma, in the meanwhile, if the petitioner, namely so-and-so, is apprehended, comma, she shall not be deported out of the country without order of the court. Next, the petitioner shall produce the certified copy of the order before the certified copy before Supreme Court. Okay, just don't say anything. Don't say anything. What was the court? List on so and so.
Milord, some protection may not be detained, Milord.
No, it can be detained, but shall not be deported.
Milord. Shall not be
Hmm.
detained, Milord. Petitioner, police is run after her, Milord. That's why, Milord.
No, she may be apprehended, but cannot be deported.
And may not be detained, Milord. Once
No,
and
no,
be
no,
admitted.
no.
29
Not 19 is 6 years.
Okay, Milord, actually, she is not received any notice, Milord.
If the notice is out, that's what. But we wanted to see the records. 10 cases are passed together
Yes,
this
10
way.
cases, Milord. Randomly incurred, Milord. May not be detained, Milord.
No, no, Mr. Ahmed. I'm not
Okay.
extending that protection.
time being item 6.
I'm sorry, Milord.
No, it's okay. Yes.
Milord, the petitioner Milord,
Once you have met and taken the wakalatnama, you'll have to assail it. This
my lord, yes,
the
Milord.
purpose of this petition is served.
Milord, that process is underway, Milord, for challenging the order. But my lord, in the meantime, as I have been, Milord, detained in the, Milord, that holding center, Milord. And I was, Milord, following the terms and conditions of the bail order also, Milord.
No, for that we asked you a question on the last occasion also.
My lord.
We see nothing on record to show that the bail in terms of the order of this court was taken.
My lord. No, my lord, on the last occasion, my lord, my lordship made a query.
Because
my
you
lord.
see, let us take it that you were on bail on the terms of Supreme Court's order.
My lord, my lord.
But that deportation process was never stopped.
No, my lord, my lord, I have served with a copy of a circular and my lord office letter of 5th of May 2025, my lord, circulated by the Ministry of Home Affairs in the Union Government, my lord.
Yes.
But my lord, when I have gone through, my lord, that circular, my lord, but there is no any specific provision is there regarding the deportation of these categories of foreigners, my lord, that how and in what manner and in which country, my lord, they are going to be deported. So, my lord, I have gone through. So, therefore, my lord, till date, from that, my lord, circular, it is transpired, my lord, that there is no specific policy for the purpose of deportation, my lord. Until and unless the country wherein, my lord, we are being accepted on being proposed that these are the foreigners of that country, my lord, it will be difficult, my lord. So, under that circumstances, my lord, may I pray, my lord, that my detention at this moment, as we are on bail pursuant to the Honorable Apex Court order, my lord.
So we are not extending that protection because the deportation process has not stopped.
My lord.
Because you will have to be taken into custody.
My lord. But my lord, from my very limited understanding, my lord, as we are on bail, basing on an
You see
order.
that bail was for COVID conditions.
My lord, that
It
is
doesn't
correct.
give you freedom.
Lord, but
Absolute freedom is not there.
but my lord, though I being a foreigner, even I assume, my lord, as a foreigner, but my lord, Article 21 is also available for me, my lord.
Yes, still you are in the country.
But my
But
lord,
you have to be, you see, once there is an illegal foreigner, he has to be pushed back.
my lord. My lord, habeas
Your
corpus,
life and liberty is limited to your well-being in the country.
my lord, no,
So
that,
it can't
that,
be, it can't be extended to the, to say that you'll be allowed to live in the country freely.
no, my lord, under certain restrictions we are living, my lord, that we have to appear before the police. We are
No, no,
confined,
that's not restriction.
my lord. My lord, this habeas corpus is for a very limited purpose. My prayer is also confined to, my lord, find out my, my lord, sister, my lord, that has already been find out, and the wakalatnama has already been executed, my lord. So observing that, my lord, can, my lord,
Because if you have any remedy, it will not prejudice you with, for remedy, if any.
my lord, my lord.
Because if you want to assail, even in the earlier case, we said that if you
Madam.
want to assail it, the procedure, you'll have to assail it.
Yes, yes.
Either you amend this or you file a fresh petition, it's your choice.
You know, my lord can close this petition with my lord, with a liberty, my lord, to challenge the consequential development, my lord.
Yes. That will give.
My lord.
Heard. Mr. A.R. Bhuyan and counsel for the petitioner. All the respondents I also heard so and so. Next para. The case of the petitioner is that the detained person is the sister.
My lord, sister of
But-
the petitioner, my lord.
The sister of the petitioner has suffered an opinion dated 19/3/2012
My lord.
passed by the learned member, Foreigners Tribunal Nalbari in is it
Because, you know, nothing, you know, that's my lord.
this page does not have the number, case number. Where will you find it, that number, case number?
My lord, my lord.
Opinion dated by Nalbari
My lord,
in FT within bracket Nalbari NAL bracket close
both are
B
same.
dash 2468/2007. Declaring the petitioner to be a foreigner. Opposed 25/3/1971 stream. Full stop. Pursuant to next paragraph, pursuant to the said opinion, the sister of the petitioner, namely Muhammad
Mariam Begum, my lord.
MUSST,
My lord.
Muhammad Mariam MARIAM Begum, was taken into custody on 5/8/2015 and detained in the detention center. Mr. Bhava pursuant to order dated 13/4/2020, passed by the Supreme Court of India in suo motu WPC number 1/2020 and order dated 15/4/2020, passed by this court in WPC within bracket suo motu bracket close 1/2020, the petitioner was released on the sister of the petitioner was released on conditional bail. Post of the learned counsel for the petitioner submitted that since release on bail, the petitioner has been appearing before the local police station once a week. Next para. Next, that on 25/5/2025, the sister of the petitioner was taken into custody by the police personnel from Tamalpur police station. And since then, her whereabouts were not known. And accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has paid for production and release of his sister, namely Mariam Begum, and for questioning the illegal detention, her illegal detention. And to restrain the respondent authorities not to resort to deportation of his sister without following due process of law. Next paragraph. Yeah, maybe. Sharma, in this prayer D is not to deport without following due process of law. We can't close this habeas corpus allowing him to amend it because it's already there.
Man,
So we issue a notice to respond to this prayer.
Lord, one thing I have annexed in my petition, my lord, regarding that deportation order passed by the Honorable Apex Court, my lord, in Rajawala Das's case, wherein, my lord, the state of Assam has furnished a list of 63 persons only, my lord. Those, my lord, persons, if my lord, just for a moment take up that.
No, we are
case,
keeping it pending. We are not closing it. Once we
Fine.
saw that prayer, we are not closing it.
My lord.
Next para. Pursuant to order passed on 25 on 26/2025, the learned standing counsel for the FT matters had informed the court that the sister of the petitioner was currently being held at holding center at Matia Gwalpara, which is recorded in order dated 25/6/2025. And pursuant thereto, and accordingly, the petitioner has met his sister in detention and in the holding center and holding area, and obtained her signature in the Vakalatnama. Full stop. The learned standing counsel for the FT matters has submitted that although the petitioner was released on bail, but the said bail order would not preclude the state from taking appropriate action against the declared foreign national. Next para. Accordingly, issue notice on prayer number D made in this writ petition, which is made returnable on how much time? Returnable in 2 weeks. We give fixed date after 2 weeks. Returnable on so and so. Next, requisite extra copies of the writ petition within, be given to so and so within 2 days. Next para. Opinion challenge করনা, বিভিন্ন record করতে হবে প্রয়োজন নেই। Uh, it may be mentioned that as the opinion passed by the consent of the consent foreigners tribunal is not assailed in this repetition, comma, there is no requirement to call for any records. Next para. The state shall ensure that the affidavit is filed within the at least one day prior to the next date of listing. Next para. In the interim, it is provided that the in the meantime, the sister of the petitioner, namely Mariam Begum, shall not be deported out of the country without order of the court. Next para, the petitioner shall produce a certified copy of this order before the Superintendent of Police border, Nalbari, to bring
Nalbari.
the order to the notice of the said
It's
authority.
now Tamulpur, it should be Baksa, my lord. It is Baksa district, my lord. Because the opinion when was rendered, my lord, it was Nalbari. Now
Acha,
that,
Tambulpur, Baksa.
my lord,
Shall please border Tambulpur, Baksa. Next para, list on so and so.
my lord. Highly obliged.
Supplementary item for motion 42 with 43.
Yes.
Petitioners are in a detention, sorry, they may not,
Lord, can you hear me, Lordship? We will not take the bank presence.
After some time. Okay. After some time. Actually, ভালো দেখে। Joint is good, is good, is what training.
Notice,
Item 44.
is it available or?
May I please, as your lordship? My lord, pursuant to, my lord, the order passed by my lordships, my lord, we have been allowed to meet and the wakalatnama has also been executed, my lord. Now we are preparing to challenge there is an order passed by this honorable court, my lord, after the opinion of the tribunal, my lord, has been challenged, no?
Was dismissed by order
My
date
lord,
30
yes, yes, my lord.
May 2017.
2000, yes, my lord. So now it had not been assailed before the apex court, my lord. So now the wakalatnama had been executed. We have advised, my lord, but still it is under process, my lord.
You can close this matter then.
My lord, that same deportation prayer is also here, my lord. That
No,
not, not to deport, my lord.
but after dismissal,
My lord.
after
That-
dismissal, we can't give that order. It will be without jurisdiction.
No, my lord, in that earlier petition, my lord, that was the foreigners tribunal order was not assailed before my lordships, my lord.
No,
And this is a case wherein my lordship's order has not been assailed before the apex court, my lord.
that's why, because if now you have to be stopped from deportation, it will only be the Superior Court. We can't stay that.
My lord, my lord.
We will not have jurisdiction. Having dismissed the petition, will not have jurisdiction.
I have understand, my lord. My lordship can pass appropriate order.
Because in the other case, it was
Yes, yes.
it's still within our
There is
jurisdiction.
restriction, my lord.
They be entertained. Had Mr. A.R. Bhuyan, running counsel for the petitioner, as well as all the respondents are there. Next,
For
madam.
honor.
The case of the petitioner is that her husband,
My lord.
namely, what is the name?
My lord, the husband's name is Mallika.
Sohrab Ali
Paramanik,
Paramanik.
my lord.
Sohrab Sohrab Ali Paramanik. Paramanik, alias Sohrab Ali
Paramanik.
Pora. Now Poramanik. Poramanik was taken into custody on 17 January. No, he was
My lord,
on 25/5/2025. He was taken into custody in Swenso, and thereafter his whereabouts were not known.
Right.
Next para. It is also projected in this writ petition that by an opinion dated 11/11/2016, passed by the landed member, you copy paragraph 2 of order dated 20 June 2025, 20 June 2025, para 2. Full stop. Next para thereafter. Pursuant to communication dated 17 January 2020, issued by the Superintendent of Police within bracket border, bracket close Chiran, Kajalgaon, the husband of the petitioner was released on conditional bail from the transit camp, Gwalpara. Next para, as the husband of the petitioner was again taken into custody, comma, by filing this writ of habeas corpus under Article 226 of the Constitution of India, comma, the petitioner has prayed for production of the husband of the petitioner and to hand him over, and to return him to the custody of his family members, comma, to quash the illegal detention of the husband of the petitioner and to direct the respondent authorities not to deport the husband of the petitioner without due process of law. Next paragraph. Pursuant to order dated 26/6/2025. No, not 26. It will be 24/6/2025. Comma, the petitioner and one family member was permitted to meet the detained person, declared foreign national, and to obtain his signature in the Wakalatnama. Upon instructions, the learned counsel for the petitioner has submitted that as per instructions received by him, comma, the petitioner and a family member could visit the holding center at 7th AP Battalion, comma, Saraikola in the district of Kokrajhar, and signature of the detained person is obtained on the Wakalatnama.
Sorry, please go on.
According to comma, the learned counsel for the petitioner submitted that in the meanwhile, the petitioner may not be, the husband of the petitioner may not be deported out of the country without following due process of law. Next para. Mr. Bhuya,
Mine.
there's 2 ways. Number one, we don't say anything.
My lord.
And second, we make an observation that since deportation was not stayed by the Supreme Court, that is to follow. So we want that in the order, or we simply say that we close it and give you liberty to hold the Supreme
You
Court.
close it and can approach the appropriate
Okay.
forum. my lord.
Okay.
My lord.
Let's see. Accordingly, comma, the court is of the considered opinion as the opinion dated 11/11/2016 passed against the petitioner has attained finality by virtue of dismissal of WPC 7579 of 2016 by order dated 30/5/2017, comma,
एक कोट लिखा था क्या? कोट प्रॉब्लम साइड ऑफ दिस फोटोज में भी मैटर रिस्की होगा.
and taking into consideration that the petitioner has been able to obtain signature of the husband of the petitioner in the Wakalatnama, comma, the court is of the considered opinion that the purpose of this writ petition is served as the whereabouts of the husband of the petitioner is disclosed. Full stop. Accordingly, it would be open to the petitioner to avail such remedy as may be available to her or to the detained person in connection with the said opinion dated 11/11/2016. Which accordingly, the writ petition stands closed without prejudice to the rights, if any, available to the petitioner and or they declared foreign national, namely
Milord,
Sorab Ali
Sorab Ali
Paramanik alias so and so.
Milord, if in future we come for the release, Milord, from the detention, present detention, then Milord, as my lordship has closed it, it will may open for make.
No, we have said it will not prejudice you, whatever
Right.
rights you have,
My lord.
all your rights, whatever is available,
Yes, yes, Milord.
it's closed without prejudice to you.
Yes,
So even if you have to move this court, it's
Yes.
without prejudice.
yes.
Item number 6 will also directly rule, I mean, executive with regard to prayer number 3. Because our part is my lord detection. Deportation is on 100%. So our part, maybe we can file a
No,
report on our-
you and the Union of India will have to do it, whatever is,
Yes,
because once that challenge is made, you'll have to do it.
yes. That's why, my lord, our part, my lord, the process of my lord, detection is completed. That there is no my lord, disputed protection, the detection is completed. Now our part is to verify and hand over the central.
File that affidavit only,
Yes, that must, because
the,
other part is under central government.
for the senior government, CGC.
CGC.
Okay, we'll see to it. And Mr. The other matter, the 42, 43,
Milord is same. 45 is also same, Milord. Here is also, Milord, facts is already there. Milord, husband is Saha Ali. We have been allowed to, Milord, meet. And Milord, the opinion is assailed before this, before my lordship, it was dismissed, but not assailed further, Milord. Situation is same, Milord.
okay.
Fine.
Only the, there'll be,
There will be an order has already observed in the first orders, Milord.
the
24,
second case, the names and dates will change.
That's the way.
Rasidata,
45,
Saha Ali, the husband.
here the name of the declared foreign national, husband of the petitioner is
Saha Ali, Milord.
Saha, S-A-H-A.
SHAHA, Milord. The page 18,
Okay, S-H-A-H-A,
HA, Milord.
Saha Ali,
And alias Saha Ali, Milord. SAH,
alias,
Saha Ali, Milord. These people has always.
alias Saha Ali, S-A-H-A,
SAH,
is Saha Ali.
Milord.
Opinion is 5/6/2017, passed by the learned member, Foreigners Tribunal Chirang, in FT case number
Milord,
FT
application
oblique CHR
08
oblique 08 oblique 2016.
16,
This is at
page
page
18.
18.
Milord.
And next part is, he was released on bail pursuant to release order dated 21/4/2020, issued by the Superintendent of Police, Border, Chirang, Kajalgaon. And the challenge was made in by filing WPC 4158 of 2017, which were dismissed by order dated 13/12/2018. And here the husband of the petitioner was apprehended on 5/6/2017 and pursuant to the Supreme Court order of 13/4/2020, he was 24/20, he passed it by the Supreme Court of India in suo motu WPC 1 of 2020 and order dated 15/4/2020, passed by this court in WPC within bracket suo motu bracket 1 of 2020. He was released by release order dated 21/4/2020, comma, issued by the Superintendent of Police, Border, Chirang, Kajalgaon. And next, he was again taken into custody on 25/5/2025. Then pursuant to order dated 20 July 2025, he was able to meet, take instructions, and wakalatama. Rest the same. Okay.
Obliged, Milord, highly obliged.
Yes, in that matter,
My learned friend had provided a copy of the circular to me, Milord. I'd like to make some submissions on that, Milord. Can you do some other day, Milord? Otherwise, because
okay. Both sides are represented. the learned counsel for the petitioner submitted that he has received a copy of the circular and waits for some time to make his submissions. Next, list after a week on a date to be fixed by the registry. Okay.
Right.
There are three items, sorry, 47, 46, 47, are the council present?
Forty-six, 47.
Yes. There's a special drive for the mediation. Mr. Acharya is also there? No. Because this matrimonial appeal, we intend to send it for mediation. It's a matrimonial matter.
Against the divorce.
Yes. Because now there is direction from the Supreme Court also to make an effort to have these matters, make an attempt to settle the matter through mediation. But give a scroll for Mr. B. Acharya, advocate. So subject to his consent, we send it for mediation. Suggest a date when it can be held.
After 1 month, any date may be.
No, suggest a date because will be, the notice will be issued on the particular day.
Yes.
For appearance. If it is 1 month, we can make it
28 August.
28 August. Okay, tentatively. This is heard Mr. A.M. Barbier and counsel for the petitioner. And second part, just leave it blank. If he comes, then write. Also heard Mr. B. Acharya and counsel for the respondent. If he doesn't come, don't write this. Next para. As this is a matrimonial dispute between the parties, comma, the court is of the considered opinion that as there is a scope for settlement of the matrimonial dispute between the parties through mediation, comma, the court is inclined to refer the matter for mediation by fixing the date of mediation on 28, you said, 28/8/2025 at 11 a.m. at the mediation center of Guwahati High Court. Next para. The learned counsel for the petitioner as well as the learned counsel for the respondent shall send a downloaded copy of the order to their respective parties, which would constitute a notice for appearance to the parties on the first date of mediation. Next para. The in charge of the mediation center shall appoint a trained mediator to mediate the dispute between the parties. Full stop. Full stop. We grant 1 month's time to the learned mediator to make an attempt to settle the disputes through mediation. Full stop. List on. You said 3 weeks. 3 weeks time make it because there is vacation coming. To complete the mediation within 24/9/2025. Or make it 23/9/2025. List on 24/9/2025. Or report of awaiting report of mediation. Okay. Subject to consent by Mr. Acharya. If his consent is not there, then we'll pass a different order. Item 47.
47.
Lordship, item number 47, conducting council went for Juma prayer. Kindly be taken at 2.
So you take his consent if that is there. And here also, you are appearing for
Anesh Lashkar.
Mr. N.H. Laskar. You give a scroll for the respondent, Mr. M.K. Sharma and K.K. Goswami. Since it's a matrimonial order, you tell Mr. Laskar to just inform the court master if the consent is there for the mediation, then we fix the same, pass the same order.
It is fixed for mediation.
He has no objection. Okay. But we wait for Mr. Sharma. If his consent is there, then we pass the same order. The date of mediation. What is the date do you suggest?
Then the lodge.
Okay. Then we make it on first sitting of the mediation, we make it on 20 August. 20 August 2025. And the what you call mediation should be completed within the same date, 23, and list on 24th. So this is orders subject to the consent from the learned counsel for the respondents. And you will send them a downloaded copy of this order so that the parties can come here and mediate. Common order to be passed in appeal and the IA. Both. Just the court master. Ajay, I want to address the land council present. The second half, there is, if there's some work, if I am assigned that work, then maybe second half I may not be able to sit. The second half the matters, but you'll come to know only when at 2 o'clock. If I am assigned the work, then maybe.
I have a matter, item 12, my lord. That may be fixed next week then, my lord, if lordships.
Just wait, we'll pass it after 2. Tell the court master.
My lord.
He'll take note of it.
So
if-
interim
Pardon me?
My lord, interim prayer is there, that is why I'm praying.
No, just okay.
My-
Just take note. Interim prayer, interim order at item number
Item 12, my lord.
12.
Yes.
Okay. Just give those where interim orders have to be extended. Please give it to the
My
court
lord,
master.
My prayer is first time listing for interim, my lord. That is why. This case has been listed for
Oh,
first
acha,
time.
you want it for,
Yes.
okay. Okay. Monday?
Well.
Okay, Monday. then.
My lord.
Yes.
Lordship, I submit item number 32 and 33, Lordship. The person is in, both the persons are in detention, Lordship. So if the matter, if possible, can take it up next week
Okay.
on Thursday.
Attention, we'll take it up.
Item number?
Item number 32 and 33.
Next week. We'll fix a date because again, there
Yes, Lord.
are several disruptions even in next week.
Item number 16 may
The-
maybe take up next week. 16, 1/6.
Next week, we have some difficulties. There will be disruptions of the bench again.
Yeah.
So
If possible.
maybe after,
If possible.
we'll keep it next week, after that. Second week.
Yeah.
Okay, second week.
Any date.
Yes,
My lord, item number 10, my lord. It may be taken up day after tomorrow, my lord.
day after tomorrow is a Sunday.
Sorry.
It's okay.
Monday, my
No, but we are not saying it because there is some disruptions again. You are aware of it. And there may be likelihood of some disruptions in the next week. If you can take it up the week thereafter, then everything will be settled.
Must.
Week commencing, next week would be, it's 28th.
My lord, can you meet me, lord? Please, lord. Please, lord, I want to present the case.
Which item number?
10, my lord.
10. Okay, then Monday. Monday 28th.
Must.
You want to hand it over in item 28?
Item 10.
Item 10, okay. In item 10, you say both sides are represented. As agreed to by both sides, this is the matter on 28/7. Next para, Mr. G. Sharma, Learned Standing Counsel for the FT matters, has written the trial court record, the tribunal's record to the tribunal's record. Also, that the same be written on record. List on so and so.
Chip,
Tell the court master, we have some work. Tell the court master, we will not be able to pass orders.